Hey everyone, thanks for logging in this morning. I appreciate it. We were just going to give a couple more people a few minutes to get logged in, so we'll give them maybe 1 or 2 minutes here, and then we'll get going. But appreciate you guys coming on and spending a few minutes of your day to talk about estate planning 101. That's pretty thrilling, I'm sure, but it is good information that's obviously timely for a lot of our clients. And so we appreciate Mike Menninger taking a few minutes out of his day to meet with people and kind of talk through some of these important topics. So, like I said, let's give us just another minute or so and let a few stragglers get in here. I will remind you that the chat is open. If you click on the bottom of your screen, there's a chat button. If you click on that chat, please feel free to ask questions as we go through this webinar today, and we will address those towards the end. I'll give you another reminder of that as we get into the webinar a little bit, but please put your questions up there. If they're pertinent to everybody, we will certainly answer them. If they are maybe a one-off conversation, we'll make sure that someone gets in touch with you and talks about your specific concerns or questions off the bat. So yeah, it's been another minute, so I think we'll go ahead and get started. I'm going to bring Mike on. Mike is the attorney with Hawk Menninger, who we share a building with. And while we're not exclusive partners by any stretch of the imagination, a lot of our clients have benefited very greatly from Mike and Rachel's wisdom, whether it's setting up estate planning options early or at the last minute when life throws you a curveball. They're pretty good at both sides of that coin. So without too much ado, I will go ahead and pass it over to Mike. Thanks, Mike.
Thanks, Cameron. I appreciate the introduction and glad to be doing this. And by the way, we'll air this out publicly. The feeling is mutual. You guys have brought a lot of value to our clients as well. So it's nice when you can find partnerships like these, and certainly it's a privilege to do this for some of your people. So I'm going to do a screen share. Hopefully our technology is cooperating today. It should. But if for some reason, Cameron, if you could give me a heads up if things aren't working the way that we want them to. But hopefully everybody is now seeing the slide that says the 4 estate planning mistakes almost everyone makes. This really is an estate planning 101 workshop. We're hoping that people can get a lot out of this. Again, if you have questions that are relevant, feel free to ask them. And Cameron, you'll keep an eye on things, and I'll do my best to keep an eye on it too. If it's pertinent, I'll jump in. You're not really going to distract me too much. Or if you want to wait till the end, that's fine too. But questions are good. Otherwise, I'll just be up here lecturing. And while I don't mind doing that, I also like the engagement. So we frame this workshop as the 4 estate planning mistakes that almost everyone makes, because there are lots of things out there that people haven't considered. And so we're going to cover a lot. It's going to feel a little bit like a fire hose because there's a whole broad scope of what estate planning is, but we're really going to try to hit the things that matter to most of our clients, and frankly where people tend to fall down until they get into a really intensive and comprehensive planning process. And so with this is kind of the framework. Oh, see, first glitch already. Let's make sure we're there. This is our agenda, and these are the mistakes that we see people make. Not having the right documents, not knowing the law, or knowing some of the law, or a variation on that is thinking they know the law when in fact the law is something completely different. And I hope to dispel some of that today. Not recognizing who the creditors might be for your estate and your estate plan, and then ultimately failing to plan for disability. Mistake number 4 is something we see all too commonly. My partner, Rachel, is a certified elder law attorney and deals with some of these situations where families are in crisis. But I can tell you that, estate planning, the thought is assets and money, and certainly that's a piece of it. But where things really get hard for families is this issue, because there can absolutely be financial loss associated with failing to plan for disability, but there is a lot of emotional toll. Even if you've already planned, if a family member becomes disabled, and then if they failed to plan, that emotional toll is exacerbated. So we want to spend a little bit of time talking about that and ways that you can get ahead of that issue. So before we get into the mistakes, I want to talk about estate planning generally. And what I'm going to do for the next hour is I'm going to read to you. No, I'm not actually going to do that. You, of course, can read the slides yourself, but this is a nice, very technical definition of estate planning. promulgated by the American Bar Association, and a process involving advisors and lawyers and goals. And this is, again, the American Bar Association. And it's not that this is a bad definition, but it feels a little bit sterile. So I want to give everybody a different definition of estate planning that is kind of a little bit more of a modern and practical approach. This definition of estate planning is not a definition that I came up with. This is a definition that I inherited. But I can tell you that wherever you are in your planning process, if you haven't started, if you're in the middle, or even if you've done it recently and maybe looking at it again, I encourage people that are willing to read this slide. I encourage you to digest it, and we'll go through it a little bit here. But if you understand these bullet points and if you believe them, as long as you act accordingly, you're going to be successful in your own planning process. But this really is the heart of what it is that I do every day as an estate planner. My clients want to control their stuff while they're alive and well. And frankly, they want to delegate at the appropriate times and under the appropriate circumstances, but they get to control these things. They plan for themselves and their loved ones if they become disabled. They give what they have to who they want, when they want, and the way they want, and they do it without having to spend a whole lot of time and money and stress, right? As a professional, it's a pretty cool place to be when I am meeting with people on a daily basis whose sole reason for coming to see me is they have other people they're thinking about. That's a really cool way to go through life and make a living, because this is how my clients approach this. And it's not necessarily about them. This is about making things better and easier for the people that they care about. That's really the heart of estate planning. It's why I love coming into work every day. Of course, our neighbors upstairs are fantastic, but it really is the clients and their motivations that drive us every day.
I'll tell you, whoever you stole that slide from, we've stolen it from you, and we use it a lot in presentations. So, whoever the initial author was, thank you very much.
Well, I think it's been passed down from generations from some very smart estate planner a long, long time ago. I'd love to take credit for it, but I can't. But I really do believe it, and it does, I think, get to the heart and soul of our job. So that's estate planning, right? Taking care of yourself, taking care of your loved ones, taking care of your stuff in times of disability and death, and trying to reduce the stress and cost. So what is an estate? Now, here's one place where I can maybe dispel a myth. I meet people that say, I don't have an estate. And I say, well, how did you get here? I said, well, I drove in my car. Do you own your car? Yes. Okay, well, you have an estate, right? An estate is what you own. An estate is not necessarily a taxable estate where we think about, federal estate taxes and millions of dollars. And it's not even an estate like after I'm gone, although that is a version of estate, a probate estate, a trust estate. But if you've got stuff, you've got an estate. And so if somebody like me, or somebody like Cameron asks you, well, what do you think the value of your estate is? You get out your mental abacus and you slide the beads across and you add it all up, but it's all the stuff that you own. That's really what your estate is comprised of. And when it comes to estate planning with assets specifically, we got to deal with all of them. We're not cherry picking things, because when we cherry pick things, they lack context. They lack context in the overall plan. And frankly, they're things that may cause headache and unnecessary cost and delay for your family later on. So,
well, Mike, I think you probably experienced this too, but a lot of times people come to us and they think, I don't have enough assets for what you're talking about. And they think there's like this magical, I got to have 10 or $20 million to do this fancy estate plan.
Sure.
That's just really not true, is it?
No, because, I'll distill it down to this. We see it regularly where somebody passes away and we still have to go to probate court for their car and their bank account. These are assets that don't have considerable value, but it takes me the same amount of time to probate a bank account that has $1,000 as it does to probate a bank account that has $100,000. It takes me the same amount of time to probate a 1982, Ford Escort as it does a Bentley. So, yes, anything that you have is worth touching if the goal is to make things easier for your people, to make sure that all the questions are answered, things get where they're supposed to get without, with the least amount of cost and stress. So that's a good point. people associate estate planning with estate tax savings. Well, if I don't have estate tax, then I don't need to do estate planning. But that's not what drives most of my clients, because you got to have a ton of money. We'll talk taxes here in a little bit, which I know you can't wait for that. That'll be the nap portion of the presentation for some of you. But anyway, if you have anything, if you're watching this on an iPad, you have an estate. So congratulations. So what are the different timelines that go into estate planning considerations? Well, naturally, while we're alive and well, and my clients want to really decide who has control and gets to decide who gets to benefit from their estate. I mean, that's not uncommon, right? We work, we earn, we save, we want to have control unless and until we delegate. But what happens if we become incapacitated due to some accident or illness? Have we decided who makes decisions for us personally? What about for our assets, right? How are things invested? Do we buy and sell this? And then ultimately, who gets to benefit from our stuff? Is it us? Is it other people? A lot of people haven't really thought through this, or they make assumptions. Well, then my spouse can take care of it. And that might be true. We'll touch on that here in a few minutes. That might be true, but it's not default true under the law. And if you are a married person, that's great that you might have a spouse to handle things for you, but one of you may not have that benefit. In fact, both of you may not have that benefit. And then the last timeline is, well, what happens when we pass away? And I think that's what people mostly think about when they think about estate planning, who gets what when I die. And of course, that is true. That is an important part. But we have to decide, well, who's in control of our stuff, and then ultimately who gets to benefit, how, when, right? These are all part of the considerations for our clients. And one of the things that we see a lot before clients get to us, and you know, there are other people out here that do the things that we do, but before people get into real meaningful estate planning, they only get to that moment of the finish line and they don't go any layers deeper. And one of the things about effective estate planning is you can still direct things, you can still control things even long after you're gone. And I say that not in a dramatic Orwellian fingers from the grave kind of sense, but your estate plan doesn't have to die with you. Well, I want to make sure that my child is in a high risk profession, a physician or an attorney, or, you know, my child is married to someone who exerts weird influence over the family finances, or I have a disabled child who has some specific needs and government benefits that need to be planned for. Well, your estate plan doesn't have to end when you're gone. You can actually build in protections for your people. You can build in pathways for how things are supposed to go. If it's a goal of yours. If it's not a goal of yours, it's not my job to tell you to care about those things. But don't assume that when you're done on this planet, that your estate plan has to be. You have the ability to provide for your family even long after you've passed away, if you're willing to go through that exercise.
Oftentimes you you lay this out kind of like a flow chart, right? If then this is your options, and that's an option you wouldn't necessarily have with just a will.
Well, you can have it with the will. You usually don't. And certainly if you have it with the will, it creates a whole other set of potential headaches and issues. And we'll talk about wills and probate here in a second, but that's a good point, Cameron. So mistake number one, people don't have the documents that they need to have. And I'm going to try to rip through this reasonably swiftly because I think a lot of you have heard of some of these, but I want to iterate the importance. Number one and number two are powers of attorney. Now, number one, we call it the general power of attorney. Sometimes people call it a financial power of attorney. Sometimes it's even titled that at the top of the document. But really, it covers assets, but it also covers other things. Who can sign contracts, who can collect on debts, who can sign tax returns, or who can pick up parcels from the UPS store. I call it the general power of attorney because it's really everything that's non-medical. And everything that is medical is covered under the healthcare power of attorney. You do not have, in times of incapacity, you do not have an automatic decision maker. Your spouse is not an automatic decision maker for you under the law. Your child is not an automatic decision maker for you under the law. And these are the documents we use to identify those people in times of incapacity, who's going to step in and have authority to deal with me and to deal with my stuff, right?
I think that's a really good point, Mike. I'm sorry, but just from the standpoint of like, not everyone has a spouse, right? So I'm sure some people feel like, well, I have a spouse, and so my spouse will have additional benefits that my current
Mhm.
life partner doesn't have. But what you're saying, in a lot of these situations, that may not really be true.
Yeah. So look, if you have a joint bank account with your spouse, yes, of course, your spouse will have the ability to deal with that bank account, but that's not because that person is your spouse. That's because that person is on the account. On the healthcare side of things, sometimes if we've been seeing professionals for a long time, if we start to slip mentally, someone can kind of look the other way because there's a relationship and a spouse can make decisions, but it's really not under any uh, cover of law. So it is not a default setting. And, the other side of that is I actually have clients who don't want their spouses to make decisions for them in times of incapacity. They have other people, children or other people. So it shouldn't be assumed that your spouse can. There may be some short runway and some wiggle room depending on who you're dealing with, but by law, you need to have someone. And you designate as many people as you can or want that you trust who will answer the bell, because if you don't designate people, then we end up in guardianship in probate court. And it's expensive and time consuming and stressful and all the things that go along with that. And I've yet to meet somebody who actually wants to have to go to court or wants to push their family to go to court. Um, and I see it a lot when people come. They have a power of attorney that they did 15 years ago, and they named their spouse. Well, imagine a scenario where somebody's spouse is now incapacitated and then they become incapacitated. If their spouse is incapacitated or predeceased, they don't have anybody. And now we're back in guardianship land. So you can name successors, and you should. Who's going to be making decisions for us in times of disability? The other two healthcare pieces, the living will is, it boils down to this. Are we going to be artificially kept alive if we're brain dead? You can delegate that authority to your healthcare power of attorney, or you can decide through a living will that says, if I am brain dead and two physicians agree that I can't be brought back, then I want to be able to die naturally without artificial nutrition and hydration. And by you executing a living will, not that your healthcare power of attorney couldn't make that decision, not that they wouldn't make that decision, but you're deciding and not putting the burden on somebody else to decide that. And, I don't know if any of you out there have been in those shoes, but if it's on your shoulders to make this decision for a loved one, there's no good answer. There's no good result. And I've lived through that in my own family. And I've been through some of that with clients too, who are, in those situations. You can delegate this decision or you can make it yourself. It's probably very obvious where my bias lies, but it's at least something worth considering. And then HIPAA authorizations is just a way for people to communicate. When the HIPAA law was passed back in the mid 90s, it locked down your healthcare information, among other things that the law did, but that's the one that it's probably most known for, at least among all of us. And which is a good thing on the one hand. On the other hand, it does prevent people from, your child shows up at the hospital because you're there and that child has no authority to know what the heck's going on. And so you can sign a HIPAA authorization as part of your global estate plan. Not, well, of course, when you go in to see a doctor, you can sign one targeted then and there. But if you do it globally, then it kind of goes with you wherever you might be. But then your kids can know what's going on. Or I have people that have put, pastors or prayer chain members on HIPAA authorizations, people that you trust with this information that can use it in a responsible way. Anytime that we can communicate and coordinate around treatment for a loved one, that tends to lead to better results. Number 5 is who handles your funeral and your burial. It used to be that your executor was in charge of that. The problem is, if I have clients that don't go to probate court, we don't ever have an executor. And so then there's a statutory schedule for who has the authority to make decisions regarding funeral and burial. But you can probably imagine a scenario, and I'm coming up with one very specifically. The old saying, if you have 2 decision makers who don't agree, how many decision makers do you have? 0. I litigated a case back in my old life as a trust and estate litigator where that was the issue. What was going to happen with dad? And because the daughters didn't agree, dad sat on ice for 2 months while we did the whole court song and dance, and it was disgusting and expensive, and for what? So Don't assume that everybody's going to do these things the way you want them. You certainly can vest someone with authority to make decisions, but like you do with the will, you can decide who the executor is and you can give them the instructions. You should do the same thing with document number 5, this disposition of remains. And then with the last will and testament and living trust, we're going to get into that here momentarily. So,
Mike, I'm just going to bump in real quick.
Sure.
Because we've had several people that came on after we started. And I just want to remind you that if you have any questions at all, though, we're doing this presentation, just click the chat button at the bottom of your screen and just type it in there and we'll make sure we answer those. So sorry, didn't mean to interrupt you, but I saw several people added on. So
no problem. Where was I? No. So mistake number 2, not knowing the law. So here's our general outline of what we're going to cover in the next few minutes here. What's a will, what's probate, types of ownership, and then trusts. So let's dive right in. So what is a will? A last will and testament. Not to be confused with the living will, which is the end of life stuff, but a will, the last will and testament. It says who's in charge of your assets when you die, and then who gets what when you're gone. But know that while you're alive, your will is just a piece of paper that doesn't do anything. And some of you may know this, but to iterate this and its importance, a will only directs assets that you own individually when you die, not joint assets or assets with a beneficiary designation. So I want to kind of repeat this again. Any asset that you own in your sole name that has no beneficiary designation on, a will only directs those assets. So if you have an IRA or life insurance policy or a bank account that's POD or whatever that is that says one thing and your will says a different thing, understand that the beneficiary designation is going to control over what your will says. That can cause some problems for clients who haven't jived those things. And sometimes people make assumptions on beneficiary designations that aren't quite right. And again, that's going to be on this list here. Another thing that I want to enforce, people miss this all the time. If I have a will, I'm good. And that may be true, but I want you to understand that if we are using your last will and testament to dispose of assets when you're gone, we are doing it in court. Doesn't mean if you have a will, we have to go to court. But if we're using your will to get assets to your spouse or your kids, we are doing it in probate court. A will does not avoid probate. In fact, a will has to go through probate if we're using it. I want to be very clear on that. All right, so what is probate? You can look at all these bullet points. I'll discuss a couple of them, but I'll kind of give you my colloquial definition of probate. It is court supervision of your person or your stuff while you're alive or after you're dead. So court supervision of your person or your stuff while you're alive or after you're dead. And by the way, people die with the will or people die without a will. Both categories can end up in probate court, especially those without a will. But even those relying on a will be in probate court. If you don't even have a will, then the laws of what they call intestate succession, which is sort of next of kin law, will decide how your stuff goes. So you don't decide, the people you elected to your state legislature, or maybe what's worse, the people you didn't elect to your state legislature will decide how your stuff goes. Probate takes at least 6 months. Oftentimes it takes more than a year. Some of that is because of the creditor claims period, the 6-month creditor claims period in Ohio. Some of it is just the practicality of gathering assets and selling real estate and collecting this, that, or the other. Average probate takes a year or more. It's not the end of the world to do, but again, certainly not the first choice when I ask if my clients are enthused about the idea that their spouse or their kids have to go to court. None of them are. By the way, probate's public, so there are some things that are restricted, but for the most part, when we have to file a probate, we put, death information, address information for the decedent, also their spouse, also their kids and grandkids, anybody who plays a part in this whole thing. We do them the favor of putting all of their information on the internet for the whole world to see. We also put all the assets on the internet for the whole world to see. And frankly, because of the way that attorneys and executors and administrators get paid in Ohio, even assets that don't go through probate court still go into the computation for how people like me get paid. And in order for me to get paid, I got to do an account with the court. So even that stuff can end up on the internet. So again, if you don't care about that stuff, I'm not here to tell you you should. But a lot of my clients are going to do what they can to keep themselves out of the crosshairs of probate court. And by the way, you can see what the average cost of a probate is. So not only are you looking at delay, you can do the math on what your estate is worth. Remember, do all the math. That's what, and by the way, that includes non-probate assets too. Like I said a minute ago, that's what you're looking at from a cost standpoint. So most of my clients are pretty eager to go through this process and find ways to reduce or eliminate the risk of probate court for their families. So let's talk about ownership, because these are ways that people try to bypass probate that can work, but I want to give a little bit of context. Obviously, sole name is not going to work, but people use joint assets and beneficiary designations. You can see, retirement accounts and life insurance, and heck, real estate can be TOD, and cars can be TOD in Ohio, and bank accounts. We can put beneficiary designations on most things, but I want to give you a little food for thought before you rely on that exclusively as an estate plan. So the problem with owning something jointly is you only own a fractional interest. Now, if you own it jointly with a spouse, that may not be a problem. If you own it jointly with a child, you only control half of that property. And if you only have half of the control, problem is you don't have the other half. And, it can also be subject to some of their issues and concerns as they go through their lives, divorces and lawsuits, etc. Putting someone on an asset as a way to avoid probate is going to be deemed a gift, which creates tax implications. It can create Medicaid problems. It's not that we don't have clients that do it. It just needs to be done in context, and everybody needs to know what the potential ramifications are. The idea of putting someone on an account as a way to avoid probate can also create an unbalanced estate, because while we might trust that our child will divide everything equally among siblings, I can tell you from personal experience that doesn't always happen. Whether it's the child becomes a bad actor after we're gone, or whether the child is simply going through something, a lawsuit or a divorce, where somebody's not going to play nice with assets that are supposed to go to other people. But the red language is what I want to focus on for just a second for our married couples that are watching this today. I meet a lot of people that say, yep, I got all my stuff joint ownership, so my spouse is taken care of. By the way, that's mostly the men. It's the provider in us and the chivalry and all the things. And it's a noble goal, of course. And of course, the wives also want this for their spouse, but I tend to hear it more from the guys in the room. So I just want to make sure, I've done this because I want to make sure when I go, it's easy for my spouse, and I get it, and a noble goal. And yet the problem is, if that's all you do as your estate plan, what you've done is you've made it their problem to do the estate planning for the rest of the family. And they got to do that with you not here, hoping, praying, trusting that they're doing what you want, but the dialogue isn't there anymore. And probably even in a time of grieving, which might never go away, it might get easier, but it certainly never goes away. And then also, what if the surviving spouse doesn't get to it in time? Because, there's simultaneous death, people can die in quick succession. So the idea of owning things jointly is part of an estate plan. It is not the end of an estate plan, because of all the things that can go sideways after the first owner passes away. Hopefully that makes sense. So Mike, I get it. We're not going to rely on a will, and joint ownership has a key to this, but what we can do is we can put a beneficiary designation on all of our assets. True. And beneficiary designations avoid probate at your death. They do. Mostly. There are some exceptions to that, but for purposes of this conversation, by and large, if you have a beneficiary designation, a TOD, a POD, life insurance, annuities, retirement accounts, all of those things, they will avoid your probate. Here's the problem. They only apply at that snapshot in time, so they lack the ability to take into account some of those what ifs. What if a child predeceases or is disabled? What if a child predeceases and it goes to a grandchild, but a grandchild is a minor, and now we've got to open up a guardianship of an estate for a minor? And then meanwhile, they're going to get that at 18, and heaven knows what I was like at 18 when it came to finances. I certainly don't wish that on my kids. They got to pay the price for, my delayed financial growth. Let's call it that. And again, reiterating that these beneficiary designations take precedent over what the terms of your will or living trust say. And this other underrated thing, and look, it seems stupid and you hope that it doesn't happen to your family, but all right, so nobody fought over the tangible personal property. You had the house transfer on death to the kids, all the bank accounts, POD, retirement accounts, and life insurance. Everybody got their piece, but we still have this house to sell. Well, guess what? Homeowners insurance premiums don't pay themselves. Property taxes don't pay themselves. The lawn doesn't mow itself pending sale. So who's going to bear the brunt of the cost to get the house sold? And it can apply to the house, and it can apply to other things as well. But if there are expenses related to you and your assets after you're gone, who's going to pay them if you don't have an estate in the traditional sense? If you don't have a pot of money set aside for that? I think a lot of families will step up and handle this, but plenty of families don't. Well, I'm not going to do it. You do it. Well, you live closer. Well, you make more money. I'm working full time. Any number of things can go wrong. So again, avoiding probate on your death, easy to do. Does it solve all the potential problems? For most of my clients, it really doesn't.
We just met with a client this morning who her sister kind of did this with her, made her POD and power of attorney and all this stuff. But her sister lives in Canada. And if you want to add a little more complexity to this thing, try being a foreigner trying to go up to Eastern Canada where all they speak is French and try and get some of this stuff done. So it's tough.
Not to mention potential tax situations of, cross-border stuff there too. Of course. Good point. All right. Well, Mike, if I don't own it and I know who's got it, I don't need to worry about any of this stuff anyway. All the what ifs are done if I just give it away. Also true. If you don't own it, it doesn't go through probate. If you don't own it, Medicaid doesn't care. Again, with some caveats, but gifting, I'm all for it. My grandma gave each of her grandkids a nice gift when they turn 18 years of age. I think that if you want to gift, you should, but you shouldn't use gifting as an end around to solve the estate planning conundrum. You should gift somebody something because you either want them to have it or it's serving another particular goal, like tax planning. But here's one of the issues with gifting. That top line, you're relying on the good luck or the good faith of the recipient if, in fact, this is meant to be an alternative estate planning technique. So I know Cameron has heard this anecdote, but I think it's instructive. Some years back, I met with a woman who she had gotten some advice that was technically accurate. She didn't want to lose her house to the nursing home. And the attorney said, well, why don't we gift it to your daughter? Her daughter was a good actor, by the way. We'll gift it to your daughter. We'll sign $1 a year lease agreement back. So you've got the right to live there as long as you want. And after 5 years, the nursing home can't take it from you. That's all true. It is absolutely true. Here's the problem. Fast forward 7 years from this whole interaction, daughter was negligent in causing a car accident, got sued, needed to file bankruptcy because she couldn't afford to pay the debt. And now mom's house was squarely in the crosshairs of daughter's creditors because it was daughter's house, not mom's. So mom gets a letter from the bankruptcy trustee. The letter says, you got two options. Number one, get out of my house so I can sell it. Or number two, make me an offer. Mom asks me, what do I do? And unfortunately, I said, you got two options, just like the trustee said. So mom ended up buying her house for a second time because she didn't want to lose it. So again, context matters. And, estate planners that are doing what they're supposed to do, we have tools that can go right at these issues. We don't have to do an end around. Mom gave the property away, not because she wanted daughter to have it. Mom gave the property away because she didn't want to lose the house to the nursing home. Hopefully you get what I mean with this kind of end around explanation. And by the way, let's just talk one of the, bear with me here. This is a little bit tongue in cheek, but I want to give you one of the best tax planning techniques that exists under the law today. And if you don't have a pen and paper out, I'm going to give you a second, get out pen and paper. I want you to write down this tax planning tip because it's brilliant and it's going to go by real quick. You ready? Everybody ready? Here's what you do. Nothing. Do nothing. But right? I'm waiting for my hi-hat. I'll give you a little bit of meat on why I'm saying that. as long as you own assets the right way, either in your name or in the right kind of trust when you die, any appreciated assets, all the gains built into that asset go away at your death. So if you literally did nothing and you had a house that you bought for $100,000 that's worth $500,000 today, that $400,000 worth of gains will never get taxed as long as you own it when you die. Your kids sell it, they don't pay any capital gains tax. That's the whole idea of carryover basis versus step up in basis. If you give your house to your kids today, that $100,000, they're subject to that later. They sell it after you're gone, they got to pay the taxes on that $400,000 gain. If you own it when you die, they don't. So now don't do nothing. Please don't do nothing as part of your estate planning process, but know that if you did nothing, you'd actually take advantage of a pretty cool tax loophole, that step up in basis for appreciated assets. So, did you write that down? Hopefully everybody wrote that down. If not, you can watch this video again and, flash that brilliance one more time. So, all right. So let's talk a little bit about what is a trust. So here's a nice technical definition. A trust is a legal arrangement established by one or more persons who, in our office, we call the trust makers. You might have heard the terms settlors, grantors. I like the term trust makers because if somebody says, well, what is a trust maker? Someone who makes a trust. That would be you as a client. Whereby a person, a trustee, holds and administers the property for the good of one or more beneficiaries. Okay, so every trust has those three roles: the person who made it, the person who's in charge of it, and the person or people who benefit from it. And it's a legal arrangement. We kind of have a casual definition. Let me grab my little device here, my little coffee mug. A lot of times we describe see my colors, they lost last night, sadly. 2 in a row, by the way, which doesn't happen very often. Anyway, a trust is kind of like a cup. And when you want a cup to do its job, you got to put stuff in it. So when my clients create a trust, the day they sign it, it's kind of like an empty cup. That's great, but we want the trust to do what it's got to do. We got to put stuff in it. So it's kind of like a bucket that holds our assets, and then we build all the instructions around it. And we put our house, and we put our cars, and we put our bank accounts, and we direct our life insurance, and we do all this with the cup, because this is how assets can pass to the people that we choose, those beneficiaries, whether it's while we're alive or after we pass away. So let's dig into it a little bit more. Trusts versus wills. When we think of a living trust, it kind of replaces a last will and testament, because this whole thing, when you're gone, can still direct who gets what, when, and how on terms that you build. The good news is if you do this and do it right, it avoids probate if it's properly funded. So this idea of, putting your house and putting your car and bank accounts into the trust and updating beneficiary designations on life insurance and retirement accounts, we call this funding. And if you properly fund your trust and if you properly maintain it, you do all the same things that you do with beneficiary designations or a will, but you get to do it without probate court. You get to do it not on the court's terms, on your terms, not with the court supervising it, but with your appointed person supervising it. And by the way, trusts are private. Trusts in Ohio are not subject to creditor claims. And frankly, in our office, the cost of administering a trust is a fraction of what it is to administer a probate estate. It goes faster. It's less stress because there's less court involved. There's less artificial deadlines. And because we've done it right, it tends to go a whole heck of a lot quicker than that year or more that most of our clients spend in probate court.
And I think it's a good point, right? I mean, you're going to pay one way or the other. Either you're going to pay now or your state's going to pay later, but there's going to be a price. There's going to be a cost somewhere.
Correct. So let's talk about revocable versus irrevocable trust. So trusts by type of trust. I encourage all of my clients to think of a revocable living trust as just a better version of your will. It still does all the same things, who gets what when we pass away, but it does it privately, not in court. And if you think about this kind of as a funnel and filter for your plan, yes, you can do the protections for your kids or your grandkids in a will, okay? But remember, if we're using the will to distribute assets, we're doing it in probate court. So we're dumping assets into the probate cup. But if we can do all the same things privately, we do it through a living trust, we take it out of probate court. So that's the real advantage, is we get to ask all those what ifs and build in all those protections and provide for minors and answer the questions about disability and divorce and all of those things that weigh on our minds as we think through our planning process, but it's private on our terms, not public on the court terms. And with the revocable trust, I'll just use me as an example. My wife and I, we've got a joint trust, and we were the trust makers, and we are the trustees, and us and our kids are the beneficiaries while we're alive and while they're alive, right? So it's really just us. And if you become incapacitated, you're still the beneficiary of your own living trust. You just tell your trustee to take care of your health and your maintenance and your support and lifestyle, all those things. But in a actually very practical way, with a living trust, there's not really any difference between you and the trust when it comes to your assets. You're in charge. You're in charge. You just have those things built in for what happens if you become incapacitated, who's in charge, what happens when you pass away, who's in charge, and who gets what and how. We'll get to irrevocable trusts in a minute. So hopefully that gives you a good once over on the types of trust here, revocable, and with irrevocable coming later. The other thing, and we hinted at this a minute ago, is when are trusts created? A living trust is created while you're alive. I mean, that's basically what that means. And a testamentary trust is one that you create after you're gone. So you have a minor child or grandchild, and you want to ensure that their inheritance doesn't get into their hands too soon. It avoids the guardianship component of it. So you can say, well, I want my child to get, a third of my estate, but until they're 25, it's going to be held in trust for their benefit. And that's a testamentary trust. It's in your documents, but it's not created until you're gone. It's just kind of instructions to the trustee. And then if that scenario applies, however you build it, then that trust gets created by the trustee at the time you've passed away. So living versus testamentary, hopefully that makes sense. So that's a little bit of an overview of trusts. I hope that was helpful, but I want to transition into the last two mistakes as we're sort of on the back end of this back half of the presentation. This is a big mistake that people make, not recognizing the predators that lurk, and not thinking through on how to plan for them. So who are these predators? We're going to go through these a little bit here, but you can see the outline here: the government, the IRS, lawsuits, even your own family members, and of course, times of disability, healthcare costs, the nursing home. Those are big threats across the board. I think the IRS is obvious. The nursing home is obvious to some of our clients, but I think some of these other ones maybe aren't so obvious. So my favorite portion, taxes. Here's just a couple things that we talk about that can help reduce taxes. Remember, doing nothing, not gifting. That's a great way to plan because it eliminates the capital gains when you pass away. And by the way, there are most of our trusts that we do also provide that benefit to our clients. They still preserve that step up in basis on appreciated assets so that our kids and grandkids don't have to eat the tax bill later. If someone happens to have a taxable estate, strategic gifting can help. Now, it is a fraction of 0.1%. So a fraction of 0.1% of people in this country that have a taxable estate based on the current exemptions, which is $13 million for a single person and double that for a married couple. Now, even when that law changes on January 1 of 2026, that number's still probably going to be north of $7 million a person. A good problem to have if you've got it, not one that most of my clients have, because my clients are a cross-section of the country. I've got clients of varying wealth levels. Some need to worry about this, most don't. And of course, gifting using the annual exclusion can help. That $18,000 per year. I'm not going to beat on this because, again, it's not what most of my clients need to worry about. But I want to say this. If you, in fact, want to gift, not because you need to do the tax planning, but you just want to gift, don't let this annual exclusion thing be the tail that wags the dog. You are not limited to $18,000 per person. What happens is, if you give away $18,001 to your child this year, nobody pays taxes on that dollar. What the IRS does is they subtract $1 from the $13.61 million exemption you've got otherwise. And only until that $13.6 million exemption gets to zero while you're alive or upon your death do we actually pay any gift or estate taxes? So you might create an accounting issue with the IRS, and I advise my clients to stay all square with Uncle Sam. But if you want to give $20,000 to your kids, to each of your kids, do it. It's not going to get taxed. Now, it's probably a good idea to talk to somebody like me or somebody like Cameron to make sure we're just doing things the right way, that we're not tripping other issues, we're not giving highly appreciated stock if there's other ways to do it. But the point is, don't let the tax tail wag the dog unless you happen to be in the, we'll say, the high seven figures for an estate. If you're there, have a conversation before your gift. If not, don't worry about it. Just make sure you talk to your accountant about filing the right paperwork with the IRS to keep count. Make sense? Terrific. And by the way, there's other things that we do, a topic for a different day, about strategies with your retirement accounts to help potentially reduce, eliminate, or stretch taxes for your beneficiaries. Always happy to have those conversations. I love doing that kind of planning, but that's a little bit more in depth than what we've got time for today. Lawsuits. Are you going to get sued? Probably not. Could you get sued? Absolutely. I'll just leave you with this one little nugget. The United States Financial Education Foundation estimates that there are 40 million lawsuits filed every year. And that, they've done some curating of data over the years. And of course, that includes the small claims and the evictions and all the kind of stuff that goes along with that. But that's 40 million lawsuits in this country every year. By way of context, there are about 31.5 million seconds in a year. So there is more than one lawsuit filed in this country every second, if you trust the U.S. Financial Education Foundation. Put whatever stock in it you want. Point is, people are getting sued, and that can absolutely affect you, and it can affect your beneficiaries even after you're gone. So I have a lot of clients that are keen on asset protection. I will tell you that the time to protect assets is now, before a claim happens. And when I say a claim, it doesn't have to be a lawsuit. If there's something that has occurred that even might lead to liability, it is too late to asset protect. Too late to asset protect. So if you want to get into the asset protection realm, I love doing it. I'm good at it. I understand the goals why my clients want to. You do it now before the bad thing happens. That's the only way you're going to get real meaningful protection. By the way, this is the piece where I think people miss. Predators out there involve your own family. You can be your own predator. You become incapacitated. You no longer have the wherewithal to manage your checkbook, and yet you still have check writing authority unless and until you've given it to somebody else or someone has taken it away from you. And I've seen clients in times of incapacity write checks that they don't remember writing, depleting their estate that they would otherwise provide for themselves or their spouses or their families. You can absolutely be your own predator if you're not paying attention, if you don't have people around you that are looking out for you. So don't discount that when you think about planning for disability. Also, the family's bad luck. I relayed the anecdote a few minutes ago about the woman whose daughter was in the car accident and basically forced mom to buy her house a second time. Daughter wasn't a bad actor. She just was involved in a situation that, ultimately created a really bad result for the family. So the family's bad luck is absolutely worth considering. Will the bad things happen to your family? Maybe, right? They get sued. What if they go into a nursing home, right? That can impact, if you're alive, your spouse going into a nursing home can impact what you've got, what you've saved, what you've earned. Or if your kids end up in a situation after they've inherited, the bad luck can impact what they inherit and their benefits. What if your kids get divorced, right? You got the in-laws to protect from. Here's this fella here. He's got two jobs, as I say. He's a gamer and an influencer. And, I try to skew young when I can, but heaven help me, I don't fully understand what an influencer is. Either way, he's really jazzed about the idea that, after you're gone, he might get half of what you leave behind for your daughter. And I imagine that you'd probably rather not have this guy get a piece of what you leave behind to your daughter. But that can happen. You pass away, they get money, they get divorced, half of that money can disappear. That is something you can plan for. Whether you anticipate it, don't like the in-laws, or love the in-laws, but still want some certainty, that is out there. Or if you're a married couple and you're watching this together, What if it's the person that's sitting next to you, right? Blended families pose unique challenges because if you happen to be in one, you might have people in your life, children, that you want to provide for, and your goals aren't exactly the same goals as your spouse's, right? But you might, of course, if you married this person, presumably you like them a little bit and may want to provide for them too. But how do we provide for that, your new spouse, without alienating your family? How do we make sure that we provide for your family without, putting your new spouse in a bad financial situation? How do we tackle these issues? I mean, obviously, it all starts with conversations and being willing to address these things. There's no one size fits all for dealing with a blended family, but anybody who's willing to have the conversation and have it meaningfully and plan through it will end up with a good result. And there's lots of techniques that we use. But simply, the sweetheart wills, I'm going to leave everything to my spouse and then everything's going to be split 50-50 between all of our kids when we're gone, can work, but it may not. Remember, think nursing home, think lawsuits. Well, what if your new spouse gets remarried? Or what if your current spouse gets remarried? Either way, once you're gone, if you've given them everything, you're totally leaving it up to them to figure this out. And you hope that they don't get taken advantage of. You hope that some new spouse doesn't come in and try to take money that you've earmarked for your kids and try to spend it on vacations and all the fun stuff. And if we don't plan through these things, these bad results can absolutely happen, even with the person sitting next to you watching this workshop. So take the time to have the conversation. I'm not afraid to put the elephant on the table and have the discussion. Even if the decision is ultimately to do nothing about it and to roll the dice, at least you had the conversation and you considered it. And I have some clients that land that way, land there, but I have other clients that want to try to find ways to make sure that we don't lose everything. And by the way, all this stuff, we're all subject to potential fraud out there. These fraudsters out there are finding lots of ways to take advantage of people, and they're getting smarter about it. And you got to be really vigilant out there. It's easy to get take advantage of. It's easy to click on the wrong link in an email. These kinds of things happen, irrespective of a spouse. But, you think about somebody as they age, older people, might tend to be, they're more susceptible to these things. So just some food for thought.
And Mike, some of these conversations can be a little difficult, can't they?
They are. And yes, they can be difficult. Sometimes people squirm, but I look at my job as a planner as not somebody who just sits and takes orders from people, but to get them to think about the difficult stuff. And I don't have,
we had a couple that actually had to take a break middle of the conversation, right? And kind of think about things a little bit. But if you don't talk about it now, you're just passing that conversation or that decision off to them on their own later. It's just not worth it. It's better to get it out on the table now.
Correct. And look, real estate planning takes work. It takes actual work. It takes emotional work. And I don't have a dog in the hunt on how people choose to plan, but I do feel it's my responsibility to get them to think about things, because I believe my job is to help people ask and answer all the what if questions that are pertinent to them. And if the answer is no, we don't need to do any kind of remarriage protection. I trust my spouse. Okay. Or I don't believe that my spouse is going to be susceptible to fraud, or I don't believe my spouse is going to go into a nursing home. Fine. But at least we talked about it. At least we considered it. At least it was an intentional decision. This last bullet point is your family's irresponsibility. I have clients that have kids that don't know money, whether it's due to age and inexperience, or whether it's simply they just exercise spendthrift behavior. And look, I own that. When I was in my late teens and early 20s, I spent money I didn't have. I didn't understand credit cards, and I intuitively would. I was academically smart, but I was not financially particularly savvy. It took a minute for me to get my sea legs under me. So how do we protect against, 18-year-old Mikes? Well, you can build that into your estate plan to make sure an 18-year-old Mike doesn't blow his inheritance, because I would have. If 18-year-old Mike had actually inherited, 43-year-old Mike would not have anything left to be said for it. So anyway, spendthrift behavior. And look, bankruptcy is kind of a similar thing. and substance abuse, right? I'm going through this with a client right now where there's some difficult conversations to be had. And, there's worry about perception and is it fair? And what if, the other kids are okay, but are they going to feel bad about being treated separately? But geez, if you have a family member that you want to provide for that has substance abuse issues, leaving them money could be, really devastating to them. And so there are ways for us to plan through things like that as well to ensure that they're, getting treatment and not using the money for things they shouldn't use it for. I know I'm running a little bit low on time here, so I'm going to try to get through this. Disability, you can see what the costs are. In Ohio, it's $100,000 to get care in a facility this year on average. Care at home is even more expensive because you see that $60,000 a year number. That's not skilled care. That basically just covers help cooking and cleaning and bathing and all of those kinds of things. And there's a pretty high chance if you're in somebody turning 65 today is going to need some care beyond what they're able to provide for themselves. So what do people do? Well, failing to plan for disability, that leads right into this. We talked a little bit about guardianship. If you don't have powers of attorney, the risk of a guardianship goes way, way up. Name primaries, name backups, as long as you trust them to be decision makers. So if somebody needs care because they're disabled, what happens? Well, the spouse or the kids can help, but that's as long as the spouse and the kids are able and willing. And if they're not, what do? Well, we hire people, right? We go to a facility, we bring care in, and what most people do when they don't plan is they pay until they're broke, or they end up passing away on their way to broke. Lots of people explore long-term care insurance. I think that's a great thing to explore for every client because long-term care insurance done right can help cover or defray the costs, and we get to do it on our terms, right? Not Medicaid is a great resource for eligible people, but people that truly want to call their own shots, people that want care at home, they can use long-term care insurance to leverage their dollars. And, this is a conversation for you to have with Bill and Cameron along the way here. But the way that they do long-term care insurance now is pretty cool because it's not the use it or lose it kind of insurance that most people associate with. It can be built on life insurance where the death benefit can really be advanced to cover long-term care. And if it's not used for long-term care, well, good news is it pays to your kids. And there's ways to do that. And Bill and Cameron are really good at that. And I think, like everything, my clients do a better job of making decisions when they have information that they can lean on. So I'll push any of my clients that are, reasonably healthy, and I say young enough, but heck, there are products available for healthy people even up to age 80. So look, it doesn't cost anything to learn, just a little bit of time. So let's talk about Medicaid here for a second. We have clients that will plan for Medicaid. They've got goals to provide for a spouse. They've got goals to provide for children. They've got, special needs children, or they've got other considerations. And the idea of losing their assets to the nursing home, it stings. The thought of that hurts really badly. And so for those clients, we go into what we call pre-planning, where we position assets to get people eligible for Medicaid. And what that does is that gives us options where if we choose to use the money that we've protected to cover care, we can. Otherwise, we can throw the switch and allow Medicaid to cover the cost of care. The issue is, if you want to plan for Medicaid, you got to do it at least 5 years ahead of time for those assets that you want to protect. For those people, and I say this probably not for people watching, but for people you might know, even if you know somebody who is in the midst of a nursing home crisis, they didn't do any planning, they're about to go in, or they're in and they're dropping 10, 11, 12,000 bucks a month, there are still things that folks can do to try to protect assets for a spouse, for kids, whatever else. That's what we call crisis planning. It's really intensive. It takes a lot of work by our team, but it's a lot to be done in a very short period of time. It's a little bit more costly than the pre-planning, but there are still options if you know people out there who are facing a nursing home crisis. So just a quick once over on this. You can only have $2,000 and be eligible for Medicaid. You can't give everything away, because if you give everything away within 5 years, the state's going to penalize you and they're going to get that money one way or the other, and you might be stuck. And by the way, while they may not be able to take your home, if your spouse goes into the nursing home, they can put a lien on it and take it when you both are gone. That's the estate recovery thing. And they will put a lien on your house and take it unless it's protected. And this is the last thing I'll leave you with here as the clock turns 1 o'clock. Irrevocable trusts. There is a version of an irrevocable trust that we do designed to protect assets to help gain that Medicaid eligibility. So if we want to tap into the trust to help pay for care or other things, we can, but we don't have to, and we can preserve those funds for a spouse or for our family members. But like you might expect, irrevocable trusts come with some permanence. There are things that can't be changed, but there are things that can, including who's in charge, the trustee, as well as who gets to benefit, the beneficiaries. And as long as we have good players involved, we can even retain that sort of backdoor access to the trust if we need it to cover care or we need it for other reasons. So it's not as though this irrevocable trust, I like to say this, the particular kind of trust we use, we call it an IPUG. Look at that cute little guy down there. It is irrevocable when we need it to be for Medicaid eligibility, but it's not if we don't want it to be, as long as we draft it that way going in. And one of the benefits, that people I think don't recognize on these is we can draft it in such a way that we don't have to file a separate tax return. We get better creditor protection, and this trust still gets a step up in basis on those appreciated assets, homes, stocks, things like that, so that after you're gone, the kids sell it. They don't have to pay capital gains taxes on that growth that you might otherwise have had to pay if you sold it while you're alive, or if you gifted it to your kids and they sold it, they would have to pay. So it's a great tool. Certainly, there's a lot more that can be said about this, but I know I'm kind of running up against the hour. Look, how do you avoid the 4 estate planning mistakes? You plan when you can, right? That's it. It's today. It's yesterday. It's a year ago. If you've done planning, take a second look at it. Make sure that you're still good. If you haven't done planning, or if you're in the middle of it, get on it. Set yourself some deadlines. Set yourself some goals. I'm not going to beat on this with people. If you know us, we're pretty easy to find. We call our first conversations Let's Talk. If anybody here wants to have a conversation with me or with Rachel at some point, we don't charge for that. We just want people to give us a little bit of data in the fact finder. This is not meant to be a sales pitch at all. But if you want to connect with us, you can talk to Bill and Cameron, get the lowdown. They'll tell you the good, the bad, and the ugly, and all the dirt. And they can make it very easy if you do want to connect with us. And like I said, we never charge for that first conversation. So,
and it's never too late to start, right?
True.
Right.
True.
I mean, just because you didn't do it last year or 2 years ago doesn't mean you should not do it now. So take this as an incentive to start the process if you haven't already.
And look, you may not be able to next year either.
May not.
And I think that's one of the things that happens. People procrastinate. Well, I got this going on this year. I'll get to it next year. A lot of people next year never comes. So,
yeah. All right. Well, hey, we thank you. Appreciate everyone's time on this call today, on this video. If you have any questions, there's Mike's information on the screen. Reach out to us, ask us whatever you need, but we appreciate the time and effort you put into this and look forward to talking to each of you soon.
Thank you, everyone. Cameron, thanks for this.
Bye-bye.